Hello students, hope you all are good. Today we will start Unit 6, Presentation, Collection and Payments of Negotiable Instruments, Dishonor of Cheque and its legal provision. Overview of this session which we will discuss. Presentation of negotiable instrument, collection of negotiable instrument, collecting bankers' duties and responsibilities, payment of negotiable instrument, dishonor of check, legal provisions. Presentation of negotiable instrument. When a buyer called Roy in the process of negotiable act accepts the bill of exchange provided by the seller, it is known as the presentment of the negotiable instrument. The drawee has to sign on the face of the bill under the words accepted. This act illustrates that the drawee is now an acceptor and thus become liable for further payments on or before the maturity date. When a bill becomes payable after sight, the presentment of acceptance is important for fixing the instrument's maturity. Presentment of acceptance refers to presenting the bill of exchange to the payer specified on the bill of exchange, asking him to accept and agree to pay the bill, usually at a certain time in the future. This is an act which is equivalent to notifying the holder of a bill of exchange and requesting an acceptance of the bill with the bill of exchange attached. If the bill of exchange is accepted in writing, the words accepted, seen, presented on the bill of exchange or any other documents related to the transaction will constitute an acceptance of the bill of exchange. Collection of negotiable instrument. One of the important functions of a modern banker is to collect checks and bills on behalf of his customers. While doing so, the collecting banker has to act with responsibility towards his customers. For example, a banker should give adequate care and act quickly to protect the interests of his customer. A banker will get protection only when he acts in good faith and without negligence. While undertaking the function of collection of checks, a banker may act either as one, a holder for value, or two, an agent for collection. In the case of collection of checks, a banker is a holder for value. In the case of uncrossed or open checks, he occupies exactly the same position as any other person who so acquires them. An agent, a banker, while collecting a check for a customer, cannot assert any right of a holder for value, for he is acting only as an agent. In doing so, he gets the same title on the check as that of his customer. Collecting bankers' duties and responsibility. It is the duty of the collecting banker to exercise the same care and precaution in the interests of the true owner of a check as a reasonable businessman would exercise in his own interest. Second, Solicitor Tarrington drew checks on Rackett's account pursuant to the power of attorney and paid them into his private account with the Midland Bank who collected them for him. Third, the chief accountant of Lloyd's Bank in Bombay was authorized to draw checks on the account kept by the Lloyd's Bank with the Imperial Bank of India. Fourth, the sole director of one man company endorsed in the name of the company checks drawn by third parties in favor of the company which collected them on his behalf and credited his account with their proceeds. Fifth, a check which was made payable to a partnership firm was endorsed by one partner on behalf of the firm and was paid into his private account for collection with the defendant bank. In collecting third party checks, a banker should take extra precautions to safeguard the interests of the true owner. Payment of negotiable instrument duty. One important aspect of the banker customer relationship is the banker's obligation to honor his customer's check. Liability. In case the banker dishonors such checks in spite of sufficient funds of the customer, he is liable to pay damages for breach of the banker's implied contract to honor such checks. The banker is also liable if he dishonors a check after misleading the customer into believing that there were sufficient funds to meet the check. Dishonor of checks. First, compulsory dishonor. In the case of compulsory dishonor, a banker has no choice but to dishonor the countermanding of payment by the customer on receipt of a garnishee order, in case of death of customer, in case of insanity of customer, in case of insolvency of customer. Second, dishonor at the willingness of the bank. A banker may also dishonor a check when it is not properly written, endorsement or crossing is not proper, there is insufficiency of funds in the customer's account in case of doubt of the right of holder. Legal provisions. Section 85 of the Negotiable Instruments Act 1881 as amended by the Amendment Act of 1934 lay down that where a check payable to order purports to be endorsed by or on behalf of the payee, the drawee is discharged by payment in due course. Thank you.